Hi, and welcome to this latest immigration law update video. In this video, I want to look at a recent Home Office concession on granting early indefinite leave to remain. So here's the policy on the screen. It's the concession to the family immigration rules for granting longer periods of leave and early indefinite leave to remain. It's a new policy, so it's version 1, and it was published on the 21st of October 2021. So this guidance tells you about early indefinite leave to remain concessions made to the immigration rules for applicants, in particularly young adults aged 18 or above and under 25 years, as in the private life rules, seeking leave based on their private life under Part 7 of the immigration rules. These are applicants who may have entered the UK as minors and have since been granted leave on the 10-year route to settlement, either within or outside the family and private life rules. So this policy arises from some litigation, and this is the response of the Home Office, and it applies to decisions from the 20th of October 2021. So there's some background there set out, and it refers to the family life as a partner or parent, private life in exceptional circumstances guidance. There's reference to settlement being a privilege and not being automatic, and why the Home Office have a probationary period of 5 years for those who meet the rules and are able to integrate into society and demonstrate their commitment to settlement, and then have a longer period for those who can't meet the rules, but where there would be insurmountable obstacles, or it would be unreasonable for a child to leave, etc. But they say for some cases, the public interest factors which underpin the 10-year settlement policy, namely the need to serve a longer probationary period before qualifying for settlement, and the principle of encouraging lawful compliance, may be less relevant. In particular, this may be the case for those applicants who were either born in the UK or entered as children, i.e. below 18, but are now young adults 18 to 24, who cannot be considered responsible for any previous non-compliance with immigration laws and are fully integrated into the society in the UK. For these individuals, it will not usually be proportionate to expect them to have to complete a longer 10-year route to settlement. Where that is the case, they should be able to settle after 5 years continuous leave. So you've got those who meet the half the life test in 276 ADE, they're aged 18 to 24, lived here half the life. Rather than expect them to complete another 10 years on top of the half of their life, they should be able to settle now after 5 years under this policy. This policy doesn't apply to those under 18. So what's the criteria? Well, that's set out on page 6. To be eligible, and now let me just go above that. This section sets out the criteria an applicant must meet in order to have their application considered under the early ILR concession. So in order to be considered under this concession, you'll need to make an application. I don't think the appropriate application is a settlement application, but it's a further leave application. And within that further leave application, raise a request under the concession for an early grant of ILR. So to be eligible to be considered, an applicant at the date of application must be aged 18 or above and under 25. So they've restricted this policy to those between 18 and 24. We'll come back to that later. Born in the UK or entered as a child, held that period of 5 years limited leave, and be eligible for further leave to remain under 276 ADE1. So that's why I say you make this request at the stage of making an application for further leave under 276 ADE. So then a consideration should be given. So it's not an automatic policy, and it refers back to the section on longer or shorter periods of leave found at page 82 of the guidance, family life as a partner or parent, private life in exceptional circumstances. So the criteria that needs to be looked at is age on arrival, length of residence, strength of connection. Was there any unlawful residence in the past, the fault of their parents when they were a child, or was it the fault of the applicant? efforts to engage with the Home Office, any previous continuous lawful leave you held, or any current lawful leave, and to what extent granting limited leave now would have a detrimental impact on somebody's health and welfare. Decision makers must weigh the individual facts of a case against public interest factors, obviously, and then the public interest factors being the need for those on the 10-year route to serve a longer probationary period and the principle of lawful compliance. But when one or a combination of the factors set out on page 6 apply, a decision maker should consider the claim in the round and whether it remains proportionate to expect the applicant to complete a longer 10-year route to settlement. And actually, taken together, these factors may form a particular exceptional or compelling reason to grant a longer period, or ILR. And the example given is where somebody can show they've held 5 years limited leave. Any previous non-compliance was not their choice or responsibility, but as a child or young adult, it was their parents' fault effectively. It may be appropriate to grant ILR on an exceptional basis. I'm not sure under this policy when you'd see a grant not of ILR, but longer than 30 months. So when do you consider it? Well, when an applicant requests a longer period, so within this FLR, requesting a longer period or ILR, if you don't grant it, you must give reasons. So there'll be a scope for challenge. So for example, if you make your request, they don't grant it, but just grant another period of 30 months, there may be scope for judicial review. So obviously decision makers told they should give reasons and engage with the request. They also have a discretion to consider it even if you don't request it. Now, this policy is a specific policy, but it's part of a more general discretion that the Home Office have to grant longer periods of leave or ILR, and that remains in place. So there is, even if you don't come within this policy, there is a general policy the Home Office have where they can grant longer periods of leave or ILR, but obviously there you have to demonstrate particularly exceptional or compelling reasons. Now, what has happened is Islington Law Centre and the Migrant and Refugee Children's Legal Unit have provided a note for representatives, which is really helpful. It's on the website of the Migrant and Refugee Children's Legal Unit. It's also on Free Movement. I'll put the links obviously to the policy and the links to this note below the video, because this is very helpful indeed. So it goes through the background, what's been conceded by the Home Office as a result of these challenges. Then it goes through the criteria in the policy under this section, who is eligible for early settlement under the new concession. So it's what we've just gone through. What about other applications for early ILR on the 10-year route? Because they note the concession is limited to those between 18 and 24, but there may be people who fulfill the concession, but for the fact that they're now over 24 and they're still on this route, on the 10-year route, but for them being over 24, they would meet this concession. And there's concern that this policy should apply to them too. There's links to the general Home Office discretion to grant longer periods and their leave to remain compassionate circumstances and their family life, private life and exceptional circumstances guidance. So have a look at those policies. How can you access the concession? Well, as they say, and as we've gone through, there's no particular procedural guidance, but it keeps referring to an applicant for further leave to remain. So the appropriate application seems to be an FLR FP. Obviously can't give definitive guidance on this. Just watch this space for further guidance from the Home Office, but this is the current thinking. Obviously supported by evidence and legal submissions, why you meet the requirements of the concession. Obviously you'll need to pay fees and the IHS, and unless you need to make a fee waiver application. If you're granted ILR, you should then get your refund of the IHS. Now, it's worth considering if you've got other people who may qualify under this concession or should qualify under the concession. So if you've got people with outstanding applications, do you need to make further representations? Have a look at page 4 of this note. What about a family unit that includes an adult child? Often you make an application on behalf of a family, obviously a separate application for the adult child, but you put them in together. What about the adult child? Should they now qualify for early ILR? What about young parents who've been granted leave to remain on the basis of EX1 under Appendix FM? And there may be young people already granted their 3rd or 4th tranche of 30 months leave to remain, and they're not at the point now where they're ready to apply for further leave. But is it worth writing to the post-decision casework team? And very helpfully, bottom of page 4, top of page 5 of this note is the email address for the post-decision casework team and the postal address, because it seems to be this team that have been granting the leave to remain in the legal challenges that have been launched. So what next? Well, there are some aspects of the policy that are problematic and need to be looked at. So obviously there's the restriction within the policy to those between 18 and under 25, where clearly there are those now over 25 who share the same characteristics to which the policy should apply and should benefit from this and shouldn't be in a worse position to those under 25. And they note that actually the people who were the applicants who were part of the legal challenges were over at 24. Also, there's the exclusion of children in the policy. So that's something that also needs to be looked at. The note says that clarity is being sought from the Home Office, and they've written to the Home Office about this, and they do ask that practitioners share their experiences of assisting clients in terms of accessing this policy and how the policy is applied by Home Office caseworkers. So it's worth, if you've got experience of this, get in touch with the Migrant and Refugee Children's Legal Unit, because it may help with lobbying they are doing in respect of this policy. But this concession is good news. Obviously, the concession is a bit restrictive and too restrictive on what it should be, but have a look at it, because you may well have a number of clients who can benefit from it and access indefinite leave to remain early. I hope that's helpful.